right. So Lance and I are here to talk about notice in zoning matters. And the impetus for this discussion is the fact that questions have arisen from time to time from residents, from board members, about the appropriate notice for zoning matters. And Lance and I, being zoning geeks, thought it would be beneficial and perhaps fun, at least for us, to give everyone a short presentation on the subject of notice in zoning cases. So I'm going to start with kind of a general overview of some of the general concepts underlying this, specifically for the benefit of those watching at home who have the same level of background and knowledge as the board members. And then Lance is going to delve more into the due process issues that kind of are at the heart of this matter. So starting off, zoning involves government regulation of the use of private property. We have a quote here from a 1925 case. I think it's a U.S. Supreme Court case. In its original and primary sense, zoning is simply the division of a city into districts and the prescription and application of different regulations in each district. And so that quote's from 1925, and that kind of coincides with kind of what we think of as the start of this era of modern zoning. So as modern zoning as we've come to know it today first came to be widely accepted by U.S. courts and practiced by local governments in the 1920s. And, you know, if you think about that, that's somewhat well after Riverside started to be developed. Riverside's a little bit unique in that it started from the beginning as a planned community, so there was some thought as to, well, we're going to, you know, this will be the business district, this will be the single family district, and we're going to lay it out a certain way with 100-foot frontages, etc. So what zoning involves is dividing a community into districts. There's business districts, there's residential districts, manufacturing, open space. And within those types of districts, there's sub-districts. So there's different types of residential districts where there may be more density allowed in a certain area. There may be multi-family housing allowed in certain areas. And business districts are divided as well into you know, what's appropriate in one type of business district may not be deemed appropriate in a different business district. So we have in Riverside 2 different business designations, one on Harlem Avenue and one in the Central Business District. And so once a town is divided itself into all these districts, we look at uses. It regulates uses within those districts. So there's a list of permitted uses, things you don't need any kind of special zoning permissions to do. Single-family home in a single-family residential district is permitted. And others are special uses. I'll talk about what that means in a minute. We also have bulk regulations within each district. So we determine what's an appropriate height for buildings within a district. What kind of setbacks do we want to see on buildings? How big do we want the lots to be? Okay, and so all those different kinds of zoning regulations and government regulation affect property that's owned privately. So one of the underlying principles with zoning is that before private property can be affected, certain notice has to be provided. Okay, and we'll get into that more in a minute. But once you have your zoning code in place, zoning is an organic thing. So once a community is built up per a zoning code, or even as it's built up, situations arise that can't be or aren't addressed by the zoning code. And so the codes, not just Riverside's but everywhere, provides for certain ways that you can achieve zoning relief. Okay, so we've listed some of the main ones here. And text amendments, for instance, that's changing the actual text of your zoning code, okay? And when I talk about zoning being organic, you think about how changes have occurred in the community over the years, and those necessitate these changes to the text. You can't lock everything in how it was in 1925. When there were, you know, still blacksmith shops and stables and all that kind of thing. So those stables, you know, transitioned later to garages, and with cars, the need for parking requirements in our downtown business districts and minimum parking being provided. And now we see another evolution where with the the advent of shared driving services and ride sharing and car sharing even, and possibly in the future these driverless cars coming along, communities are starting to look at decreasing their parking requirements, and especially in these downtown, more transit-oriented development areas. Okay, so again, it's organic. We have new innovations, like we imposed regulations regarding solar power here in Riverside. That's something that wasn't really necessary 60 years ago, but now it's something that people are interested in, and we want to regulate that and make sure it's being done in a way that works for everybody. The small cells that we talked about are another thing. It's changing technology. New uses come along that we want to deal with. We made provisions to allow a craft distillery. That's a new concept that came along, authorized by Illinois law, so we wanted to open up our community and make sure that we were allowing that to happen. Brew pubs are another. Implementing policy changes. We talked a lot about porch regulations a couple years ago, where we wanted to emphasize that we like open front porches, and we're going to incentivize that, but we want to make sure that they're done the right way and not coming too close to the parkways, et cetera. And then changes to bulk regulations or things like that. We've made changes to sidewall garage heights before, or even heights of garages as we start talking about things like car lifts. New innovations come along that cause us to maybe rethink how we want to word our regulations. Okay, so those are all text amendments. We also have a different kind of amendment called map amendments, and that's where we're changing the actual zoning of a particular parcel of property or an area. And an example of that is the gentleman who came in last year on Ogden, who was designated as a certain kind of business district. He wanted to do something that wasn't allowed under that designation, so he asked to change his property to a different designation that would have allowed him to do that. And the board looked at that and considered that. And if that would have been granted, that would have, we would have gone to our zoning map and changed the actual designation of that particular lot. Special uses are something, we talked about permitted uses, you don't need any special relief. For a special use, it's something that we've generally said that's okay to do in this particular zoning district, but because of the specific impacts it may have at a particular location, we want to look at it on a case-by-case basis. So a good example of something that is a special use in most communities is a drive-through restaurant. So we see, when you think about a drive-through, especially adjacent to residential, you may have lights shining into people's windows, you have loudspeakers, you have radios, you have cars idling, you have potential litter issues. So there's a lot of things that we want to look, car stacking, we want to look at how that's all set up, and with special uses, we have the ability to impose conditions that make it a good fit for a particular location. All right, daycares are another. We talked about the daycare recently. We're concerned with daycares about the pickup and drop off is often different than a lot of other business uses. We have kids running in and out, not just for pickup and drop off. We have them coming out to a playground. Sometimes it's off site. We want to see how the traffic flow is going to work. We want to know about the hours, security, all those different kind of things. So daycare are another common special use. And lastly, we have variations where somebody is actually asking for relief from the application of a particular requirement in your zoning code. So I want to build a 24-foot high garage, and the code says I can only do 22. I feel that I've got something unique about my property that Sonia's correct. It was hypothetical, Sonia. There's something unique about my property that I should be allowed to do that. And variations are important, especially in Riverside and these other older communities, because we all know the topography of Riverside, the winding streets, the odd-shaped lots. If you think about a new 20-acre subdivision out in the Collier counties where you can divide it all up with a grid street system, have lots all exactly the same size. The developer's offering 7 different models. We all know they're going to be within a certain building pad. You can create a completely conforming subdivision in that way. But Riverside's not like that. It's almost impossible to create a set of zoning regulations that are going to cover every contingency or make everything conforming. And so we have the need for variations where somebody's getting relief. and you know, just as an example of how odd things are get, we dealt with one in River Forest recently where there's a 7-sided residential lot. And you can imagine the setback issues and what's frontage and what's not, and all kinds of crazy stuff that went along with that. And not only that, they had a main ComEd power line trunk running through their backyard, which added a whole other level of intrigue.
Now, go back 1 second. I want to make one point before you start getting into the notice. So, remember Michael's example, and by the way, good evening, everybody. Michael's example of the property on Ogden, where they wanted to do a use that wasn't permitted, so they applied for a map amendment. But as Michael gets into the different notice requirements, think about this for a second, because didn't have to do that, right? Could have done any one of those four. Could have said, you know, I would like to apply for a text amendment to add the use I want to put on that lot as a permitted use in the zoning district I'm in. Get to the same place. Or a text amendment that would create a special use that's possible in that zoning district, so then you got both going. Or some communities do allow use variations. I'd like to apply for a variation from not being able to do that use. So there are ways that they could do it, and it will be interesting to think about that as Michael gets into the different statutory notice requirements now. Well, notice in general, but more specifically statutory and local.
Sure. So you know, as I mentioned earlier, notice is kind of an underlying principle of all this, and so when somebody's asking for zoning relief, you know, there's notice requirements, and there's 3 different kind of notice requirements that we want to talk about briefly. The first is statutory requirements, which are state requirements, and the important thing to remember about these is this is jurisdictional. As a non-home rule community, the village must follow the notice requirements provided by the municipal code, the Illinois Municipal Code.
No matter how pointless they may seem.
We also have local requirements. These are additional local Village of Riverside requirements and procedures that we have voluntarily put into our code and beyond what's in the state. And I'll talk about those in a second too. And then lastly is due process. And due process looks at the notice issue from a U.S. constitutional point of view. And as Lance will explore in a minute, in rare instances it's possible that more or different notice might be required under due process. All right, so real briefly on statutory notice for zoning relief. So again, we must follow these state of Illinois requirements, and for any of these different types of relief, one of the base requirements is this public hearing requirement, okay, and that includes a published notice. And kind of delving into the history of that, the reason that published notice, and there's a lot of it littered throughout the state law, not just in this instance, but you know, when you think back 50, 60, 70 years ago, almost everybody was getting a daily or a bi-weekly or a weekly paper. And it was easy for them to be able to flip to the legal section and look at the notices if they're curious what was going on in their community. And so the statutes use that as a way to get the word out to people as kind of a requirement that was necessary in all these different instances. And you know, that's kind of less effective these days. There's fewer subscribers. Some people are reading online. Some towns we found now that we're dealing with don't even have a local paper that we can put it in. So, you know, you're publishing in the Sun-Times, and even less chance that people are necessarily going to see it. But all that's still kind of this base requirement in state law until that's changed. And there's other requirements under state law in terms of mailing to adjacent neighbors in some instances, etc. But publication's the base one that we want you to be aware of. And then we have our local requirements. So these supplement state law requirements. Some are mandated in our code. You know, we have a 250-foot mailing requirement for map amendments, for instance. So in the case of the Ogden property, we have this property, we figure out who's within that radius, and we send them notices. We also have a sign posting requirement in some instances where we put a sign on the property as an extra way to help make people aware that something's going on with this property, and there's phone numbers to get more information, etc. And then outside their code, the village also has some kind of voluntary things. We send out these e-blasts. There's social media There's live streaming of meetings, not just the board meetings where these might be discussed at various points, but of the Plan Commission meetings, the PZC meetings. Those are then subsequently available on YouTube. So if somebody learns about something late, but it's still moving through the process, they have the opportunity to go on and look back and kind of catch up on that issue by looking at the meetings where it's been discussed. So those are some of the ways that Riverside supplements those state law requirements. As a side note, in looking at this, in working on issues leading up to this presentation, we noticed some old requirements in your code that may or may not be being followed. There's things like the village clerk is to transmit an application to the board, and it's supposed to be entered into the minutes at the next meeting. And so there are some type of archaic requirements in your code that are certainly not legally necessary, and we view those requirements as directory, not necessarily mandatory or jurisdictional. And what that means is the failure to perform them won't defeat or invalidate a zoning action. But all the same, having become aware of them, we should either start performing those, or maybe better yet, if they're not serving a particular purpose, we can just take them out of your code. All right. And with that, I am going to turn it over to Lance to talk more about the due process.
Thank you. Is this way to the right? Okay. So, due process is a very odd fit with zoning regulation. So we're going to go back to Magna Carta, okay? And we're going to go back to the initial limitations on royal prerogative, okay, which is due process. And that is basically before the government either imprisons you or takes your property or takes your property on behalf of someone else through a legal lawsuit, like when I sue you, I want some money, and the court sides with me against you. Without due process there, it could be done without even telling you. You could find yourself under a court order that you had no notice or way to participate in, or without a hearing. So the initial concept of due process has nothing to do with zoning, and it's actually an odd fit because it's a court concept. Due process is you have to have notice that either someone else wants your property, or the government wants your property, or the government thinks you're charged with a crime and wants to imprison you or fine you. You need to be given notice, and you need to be given a hearing. Due process is notice, hearing. Those are the components. It's a binomial kind of thing. Notice, hearing. You have to have notice or you can't participate. You don't have to participate necessarily, and that's why there are things like default judgments, but it's basically a juridical concept. It's a court concept. So how does it get involved with zoning? This way. Normally, as lawmakers, as a village board, you're not a court. You don't decide cases exactly. What you do is you make rules. You make laws. And laws typically don't require any kind of notice and hearing. Think about it. You make laws every day. You could raise the taxes to a certain degree under state law, but you can raise taxes. You don't need to send notice to every single village person, even though you are taking some more of their money. It's because it's a law. It's not a judicial order. You can change the rules of the road, change the rules for how somebody can drive through town, can change the weight limit on a road so that someone has a harder time getting through town than he should have before, or could have before. All those rules that affect people very much, depending on the individual, all those actions are taken and changed without any kind of notice and hearing whatsoever. So how is zoning different? It's different because historically, real property or land has been viewed as unique. Certain kinds of contract actions, relief is available if it involves land that isn't, if it's involved in any kind of other contract action. And because land was unique, when zoning came into play, almost universally the idea, and it was supported by some court cases as well, was that there needs to be a public hearing before you affect people's property rights, what they can do with their own property, and whenever you have a hearing, you need some kind of notice. So when we look at due process, though, it's not a notice has to be like it is in a court hearing all the time, or the hearing has to be like a criminal case. And as we know, even within the court system,
the kind of hearing you get and the kind of notice that's required varies depending on what kind of case it is. Criminal cases require more elaborate kinds of notice and hearing than civil cases do, and small claims cases are more flexible notice and hearing, and sometimes discovery rules change. All kinds of things change. And the reason for that is because the U.S. Supreme Court has said long ago that due process is a concept that varies depending on the nature of the property interest, and remember that's government affecting taking property, and the imposition on the property owner. And here we're going to talk about real property, land that people own in town, but it could be anything. It could be yourself if you're going to be thrown in jail. It could be your money. It could be a repossession. It could be anything like that. So in other words, it's a case-by-case basis. So we need to unpack those things just a little bit in order to understand them. But in the zoning context, it is that connection of real property being special that ties it in to a public hearing requirement, and whenever you have a hearing, you have to have notice. So in a zoning context, the nature of the property interest are basically, again, binomial. You're either directly affected or you're indirectly affected. And by that, I mean the zoning rule, either general rule or variation or special use, either you want it and it's affecting you directly, or the government is changing the zoning to make it less desirable for you perhaps. You're directly affected because the rule affects you as the property owner. It's direct. The other basic way to affect property interests in a zoning context is as a neighbor, as a resident who's not the owner. And the law typically, through the notice requirements in state law, treats a kind of, the closer you are to it, the more of an interest you have. And, you know, in the state law, there's the 250-foot rule in certain cases, and the village has adopted that in certain cases. But home rule communities often lessen that, and in certain cases, for what they call minor variations or something, they might only require the adjacent neighbors to be given any kind of notice. So it's a flexible concept, but it's the nature of the property interest. Are you direct or indirect? The other thing to look at is how much of a burden. And one of the things we wanted to clarify here is when some of the various concerns that were brought to our attention, we noticed that some of the cases that were being used for affecting personal real property, I should say, were takings cases and not zoning cases. And it's very important to distinguish them, because a takings case is where the government actually says, I want your land. I need it for a park. I need it to widen the road. You need to give me title to your land, or you need to give me an easement. And and I'll negotiate with you, but if we can't reach a deal, it's so important to the community, we're going to take it. And the law allows that, but you need to take it through a lawsuit, a formal lawsuit, not through a zoning hearing before the ZBA. You actually have to sue the individual who owns it for title and explain why it's a public purpose, and then you're entitled ultimately, if you can't settle the case, to a hearing on just compensation. And the notice in that kind of case is being served personally by the sheriff or by an alias through alias summons personally, or there's no jurisdiction over you and the government can't take the property. There are ways around that if you were avoiding service, but generally speaking, you're entitled to be handed that piece of paper. Zoning's different. With zoning, you're not getting title to the property, you're regulating it. The government is saying, in the interest of people living in a close-knit community and living basically on top of each other, in order to keep peace and in order to make sure that people's investments are not diminished by what their neighbors do, we're going to lay right out front what the rules are when you build. And you've got to build within these rules so people can rely on them and know what their neighbors are going to build. And if their neighbors want something else, that's why the variation process requires notice to the neighbors. They get to come and say whether they disagree with it and why. So it's different. It's really rulemaking. It's more akin to changing the rules of the road, which can affect you to a great degree. But again, because it's real property, it's subject, those rules, in order to pass a zoning law under Illinois law, you have to have a public hearing with publication. So the nature of the interest the nature of the interest is important, and the burden on the property. Is it a regulatory rule, or is it a taking? So let's look at that in the context of zoning and what we've talked about so far. Notice and hearing. So in pure legislation, just to review, there's no notice, there's no hearing, unless the legislature decides they want to hold hearings, and that does happen sometimes. If there's a taking, it's a formal lawsuit, and if it's a zoning issue, it's kind of a hybrid. And in zoning, the fundamental way to give notice of creation of a zoning code and changes of a zoning code is publication, and it's always been publication. And as a general rule, publication is sufficient notice under the Due Process Clause. Now, you have to follow Illinois law or it's invalid. But publication is always required and almost always sufficient as a general rule. Now, I say as a general rule because when we talk about direct effect, zoning actions can have a very significant effect on what somebody can do with his or her property. And that's why Riverside has a notice requirement when you do map amendments, because if someone's zoning designation is going to change within the system, the neighbors may be concerned about that because that person may be able to do something that they couldn't do, and the property owner may be very concerned with it if he didn't apply for it or she applied for it, because it may be what's called a down zone, okay? And the key area to be careful about under due process, in our opinion, is any map amendment and any text amendment where you're directly affecting somebody's property that's, objectively speaking, probably a down zoning. It's lessening what they can do with their property. And there's a case where an Illinois court found that due process was not met in the context of a map amendment. Under Illinois law, under the statute, there's no notice requirement for sending notice. There's only a publication requirement. And the municipality followed that and was sued by the property owner when the property was downzoned, and they said they weren't given proper notice. They never showed up at any of the hearings, which is significant in just a minute I'll get to. But they sued saying, hey, you didn't really tell me that you were going to downzone my property. Now, the key fact to know about that case, though, is that the government, the administration, knew extremely well that this person in the recent past had come in to prepare for an application to build according to the use that was allowed by that property. They had been in, had conversations. The government, the administration knew that they were planning to build multifamily use, which the village decided it didn't want, or the municipality decided it didn't want, and it never gave any kind of direct notice to that property owner that they were considering pulling the rug out from under them and rezoning it to a single family. And that to me, that's very important because it's kind of a standalone case in a certain respect. But it does also teach us that direct regulation, particularly if it's objectively lessening what you can do in a significant way, should require direct notice. And that's why map amendments, we always recommend sending notice to the affected property, the directly affected property. And text amendments, and think back to how, remember when I barged in on Michael's presentation on those circles? A text amendment can be a way to get the same result as a map amendment. And those also don't have anything beyond a publication requirement under state law. So what's really important is to realize that. And that's why it's been suggested, well, shouldn't we, when we do a text amendment, properties can be affected. They can, legal nonconformities can be created. And so then the thought is, well, shouldn't we just give direct notice, a mailing, beyond publication to anyone directly affected? And the point I want to make about that we think is important is you have to be careful when you're talking about something other than a map amendment where you know this lot is going to become something else. And the thing to be careful about is that you won't necessarily know all the properties that are directly affected. It really depends on what the text amendment is. And it could also be a whole lot of properties. And the more there are, the more likely it is you may miss one. And so recently, it was the daycare rules, right, Michael?
Yep.
You made some changes to the daycare rules, and it was a text amendment, and direct notice was sent to all the affected property owners.
The property, it was a very finite group of properties in that zoning designation, so we're able to identify, these are the 15 affected properties, and we're gonna send notice to all.
And the reason we're concerned about getting them all is due process. It's actually more equal protection, but that's related to due process, fundamental fairness, basically. And that is, in the effort to try to make sure you satisfy due process, you don't want to violate it. And if you give direct notice to people that are directly affected and you miss a couple, and those people happen to get really upset when they find out they weren't given notice, and they find out a bunch of other people got letters and were able to participate, if they were to bring a suit, that would create a significant problem because you went out of your way to give special notice, but not to everybody. And so that's why we say it's good to give notice to everybody direct, but you need to be careful and you need to be sure that you've got it all. You've got the body defined well enough. And I think you also need to look at realities, which is you have a very small staff. And so you want to make sure that if it's, half the town, you're likely to miss some, and do you want to do something more general that is cheaper, but as effective perhaps. The e-blasts, special notices at board meetings on the website. And so it's very important then to look at each thing you're doing as a case-by-case basis. You always follow the Illinois law, but we need to look at is how big an effect is this having? Is it a significant downzoning? Is it a case where we want to give direct mailing or not? The other thing about due process that's really important to keep in mind is that the failure to give a notice that might have been required will not defeat or not invalidate a zoning decision if the person ended up participating anyway, but without the help of the municipality. So unlike publication, where if you don't do it, it's invalid, if someone was entitled to notice, like if the fellow in the Pasolino case in the city of Zion, if he happened to catch wind of what the municipality was trying to do, and he ended up showing up hot at the public hearing and say, you didn't even send me a letter, and he made his point and he lost, his due process rights wouldn't have been violated. Now that doesn't mean the decision can't be invalidated, right? Because we're not going to talk about that at all tonight, but any decision by a municipality that affects somebody's property rights can be challenged. There's a standard of review that's followed, and so that's a whole separate thing. What we're talking about here is, did you get the proper notice so you could meaningfully participate? So if you got no notice, and it would have been a due process right, if you happen to find out and you show up and you participate, you've had your process. You had your notice.
Continue, Mr. Murray.
So as we look at this then, we need to look at, we covered all this. So when you're looking at legal sufficiency of notice in general, we look at these areas. First, you start with adequacy under the municipal code. If you were home rule, you could make lots of changes to those basic rules, but you cannot. So you have to follow them. And then you look at your own code, particularly the notice requirements, and you follow those, because notice requirements would probably not be deemed directory, like sending the clerk sending a letter to the board for scheduling or something. So you want to follow those, and then you should also think about, is this notice enough? And in this day and age of transparency, you're always looking to provide more notice anyway, so it really shouldn't be much of a problem. But you do want to look where you're doing any kind of amendments where you're not sending notices normally, like variations and special uses and so forth, or map amendments, you already require notices locally, but so basically text amendments, and you want to look and see whether this would directly affect a group of people and whether you can define it sufficiently enough to send a direct notice so that you're confident you've got everybody. The last point I wanted to make just real briefly is to talk about the concept of legal nonconformity, just real briefly. Because although legal nonconformity is a concern when you're marketing property and it can affect it, legal nonconformity is a necessary byproduct of being able, and as Michael pointed out, the text of a zoning amendment being organic, it has to be able to be changed. And where someone has already developed property, if you're changing the rules or tightening them up because you want to create bigger setbacks, modify certain things, you're going to create legal nonconformity. It's almost, it's almost as night follows day in certain, especially when we're talking about the bulk regulations. And so legal nonconformity, the legal nonconformity is actually a protective requirement for existing structures where the law, by mandating that existing structures be respected, they're being treated as legal but non-conforming, and you must allow them to be maintained. But constitutionally, as a property rights matter, you can sunset them. You don't need, if you allow a sufficient period of time, you don't even need to allow them in perpetuity. Like you have some certain, under your sign code, you have some sunset. And I believe years ago, there may have been a sunset provision relating to 2-unit and single-family houses where they were extinguished over a period of years. I seem to recall that. And so you can even extinguish them, but most communities simply let them exist in perpetuity as long as they're maintained. So that's the point I wanted to make about legal nonconformity. So we wanted to have a chance for there to be some questions, because we know this was an issue that some found concerning and maybe confusing, and I don't know if we've made it more confusing or we've helped, but we wanted to give this background. I thought it might be helpful.
You had me at Magna Carta, so.
Yeah.
So, questions, comments from the trustees?
Well, I just want to say thanks, because I know you've answered a lot of the questions that I received from village residents and understanding that. I think the bigger issue for the board and for the commissions is to try and really do a good job of adhering to transparency, especially when there's a potential for downzoning. And the downzoning doesn't necessarily become, in our eyes, it could be in the individual property owner's eyes.
Well, that's right.
That's the challenge.
I had this discussion with one of our partners where in a given municipality that shall remain nameless, they were actually considering changing the zoning requirements to make them more lenient. And so we were talking about what would be required, and we're talking about whether certified mail required. I said no, I don't believe so under due process. As long as the notice is sent for zoning, it doesn't really matter whether somebody got it or not, because it's published too, and people can get it different ways. But so we talked about that, but he also said, and it doesn't matter as much because we're not downzoning it. I said, well, I wouldn't rely on that because that's in the eyes of the beholder.
Yeah.
It's very subjective, and so I think that's a very valid point.
And I think the other thing too is that the mission for all of us on the village is to protect the village from getting into gears like Zion did. And it's very costly when you get into gears. So if you're going to make a text amendment or zoning change that happens to potentially have a downzoning, it better be damn well justified. Do no harm, or if there is something, it better be really, really well justified from a public safety perspective.
Right. I mean, it's a valid policy point to say we want to minimize creation of legal nonconformity. I mean, there's nothing wrong with that. I'm talking about solely from a constitutional standpoint. Not a,
Good, thanks.
I'm sorry.
No, I'm fine. I just wanted to thank you guys. This is very helpful, and I hope at least we have it on record. People can go look at it. I mean, because I know, again, this was in response to a lot of people that were feeling like we weren't being transparent when all of us feel we've been incredibly transparent. And so hopefully we can continue to help educate and help just to make sure we're all, expectations are well aligned. Thank you.
And to follow up on that, that's kind of the question I had. Other than those archaic requirements that we need to get out of the code, did you find anything in our current code that gave you any concern in terms of how we currently handle notice requirements?
Yeah, it would be very difficult, like you could say, well, let's add the notice requirement for map amendments to text amendments, but you really can't. Because if it's not a text amendment that affects properties directly, you're gonna be 250 feet from what, you know?
Again, I think I probably would have brought that up for us after speaking with this and doing some research, but it's a challenging, it's a challenging one. And again, I think just keeping everybody as well educated as possible and over-communicating rather than under-communicate without getting us into trouble.
But one thing that some communities do, that you guys sometimes do voluntarily, but not always, is if there's going to be a text amendment, sometimes the board will kind of bless it first and before it moves to PZC, so that you have an opportunity to consider, you know, what's the impact going to be and what kind of notice, maybe extra notice.
That's good advice.
Let me follow up on that too, that who makes this decision? Who decides what manner or what extent of notice should be given? Is that our staff in conjunction with
It
you?
depends on whether if it's in your code, you've made the decision.
Right.
But otherwise, it would normally be staff that makes the decision, and they would normally follow the rules. But if they had any questions, they would ask us. I think we might need to do more. Do you think we need to do more? You could also, if you followed Michael's concept with text amendments, because those can be either of general application in various districts, or they could be, in the case of the front-loading garages, they were more tied to, similar to a map amendment. You could conceptually say, or one of you weigh in and say, hey, I think this affects people, and then discuss what notice beyond what your code requires as part of sending it to the Planning and Zoning Commission for the public.
So that's what I want to follow up on, because as a retired lawyer, that, especially with regard to the equal protection aspect of this, if you start making kind of one-offs, where you say, well, you know what, we think in this instance we should give more notice than we are legally required to give, does that raise any concerns in terms of the village, that the next time that we don't do that, somebody says, well, you gave direct notice over here when you didn't have to.
It's a concern.
You didn't give direct notice here.
Right, it's a concern, because you may think, oh, this text amendment we don't think is significant enough to warrant it, but again, somebody subjectively may feel that way and say, hey, you violated equal protection, you treated me differently. Now, the standard, absent any kind of racial discrimination, it's a rational basis standard, so it's not a really high bar, and if you really weren't trying to hide anything, and it really was less significant, it probably shouldn't be a big deal, and probably wouldn't trigger a lawsuit anyway, but you run certainly the risk of someone saying that and feeling that way, yeah. That is a
And that's kind of what we encountered. Again, from all the research that I did when we got complaints, we're doing it, other than a few of those archaic ones that we kind of came across, we're doing it legally. But the village, a lot of folks feel we're not doing enough. And so the question is what do we do and how do we do it without digging ourselves into a bigger trap?
Right,
That's
that's right. That's a good way to look at it.
It's a double-edged sword there on that, so.
That's right, and you always have to be careful. Because almost no matter, well, you know, the thing to remember is no matter what government does, someone's going to feel violated somehow, you know. It's just human nature, so it's
President Sells?
Yes, Mr. Pollard.
I wanted to, you made one point that I wanted to make, and that is that I think it's important that subjectivity and judgment be taken out of it, because I couldn't agree more that once you do it one way for one thing and someone
That's right.
disagrees the next time, the village is in trouble.
the only problem with that is I'm sure that's exactly what the staff said in the Zion case.
Yeah.
Why should we do anything different? This is what the law says.
Well,
You know, the one-
and
I mean-
on top of that, make sure that your law and your rules that you're following are comprehensive
No, I
and
understand,
complete.
but I'm just saying, you can't ever be like really sure, right? It's like when
Right.
clients say, well, you know, so we can't be sued if we do this, right? So, really?
And the other thing I wanted to just clarify is something Trustee Lumsden said, which I started to agree with, but then maybe I don't. He said that we need to always, when we're doing a down zoning or text amendment, we always need to be very, very careful about justifying it. which I agreed with, but then you added from a public safety perspective. I just want to ask the attorneys, is public safety the only criteria that we need, that can justify a text amendment?
No, aesthetics are the other big one,
But
and I mean,
if we go down an aesthetic path, don't we need to have a competent aesthetic review board?
no, I mean, as a matter of fact, what I mean by aesthetics are objective aesthetics. Those review boards create a danger of their own by trying to decide what color paint people can
I
use.
agree.
What I think Trustee Pollock is talking about is there are certain setback requirements have nothing to do with public safety.
Yes, I don't see that as an aesthetic thing. I
No,
see
but
that
it
as a-
can be.
It's a subjective
Think
aesthetic.
about the solar panels as an example,
Yeah.
so that has a lot of aesthetic implications, which is why we can, it made
You have to put
certain
them on.
determinations as to where they
Ours-
could be.
Ours
on
currently
a
just
house.
says you can't see it from the street, right?
Yeah, but that's aesthetic. It's got nothing to do with public safety. It's not like they're
You
gonna
said
fall.
that.
And you can put them in certain areas that are viewable from the street, but there's limitations on it, so.
Yeah, those are aesthetic. I mean, not aesthetic in the way you meant it, Trustee Lumsden, where, you know, we want to look at the design of your house before you can build it. You know, there are communities that have architectural review boards. I don't like
You wanna talk about
them.
a
I don't like
Yeah.
them at all. You know, to me, if you want aesthetics, you know, regulate the amount of driving you could use, cheap materials. You can do things objectively that make sure you have high-quality structures, but don't regulate taste. It's a dangerous road to go down. I agree with
Other
that.
comments, trustees? Anyone from the